Hi, everyone. I'm just handing over to the moderator of this conversation. We have a few members of staff here and others are coming, and the dean is already here, so we can just start. Over to you, Fiona.
Okay, thank you. Thanks for coming, everyone who is online and who is in person as well. So my name is Dr. Fiona McKay. I'm at Strathclyde University in Glasgow in Scotland, formerly until recently at Robert Gordon University as well. Dr. Olufemi Ilesanmi has invited me to moderate the first of the cross-cultural conversations today. So it's a real privilege to be here. Thank you. So the nascent forum for the study of jurisprudence and value inquiry has participants and participating members coming from universities across the UK and internationally. And our approach to the study and inquiry is both interdisciplinary and cross-cultural. So for now, the focus is on the non-Western world, and we seek to gain insight into worldviews and values that shape scholarship and engagement with law and legal education in those jurisdictions. So a series of cross-cultural conversations has been created to engage scholars, legal practitioners and policymakers. And the theme of this maiden conversation is understanding African jurisprudence and the philosophy of law. So we're going to have two speakers today and then time for questions afterwards. So we're going to start out with a talk from our guest author, Associate Professor Idowu William, who is Associate Professor of African and General and Comparative Jurisprudence from Olufemi Ilesanmi University in Ile-Ife, Nigeria. And his areas of research are philosophy of law, social and political philosophy, and advancement of learning in the field of African jurisprudence. And following this, we'll have a response from Professor Jill Stavert from Napier University in Edinburgh in Scotland, who is Professor of Mental Health and Capacity Law, situated within the School of Health and Social Care. And her area of research is on research and expertise in international, European and national human rights and mental health and mental capacity law and related law, policy, practice review and reform. So we're going to start off first with a welcome address by the Dean of the Law School, John Clifton at Robert Gordon University as the conversation host. So I'm just going to invite him for the welcome address, and then we will start with the first of our talks for this afternoon.
Thanks very much indeed. I see on the schedule that I've been put down for 5 minutes, which is obviously damage limitation here, no doubt about that. I'm going to keep this very, very brief indeed. I'd like to welcome you all to this event. Oops, sorry, I've been stage managed. I have to go over here. Right. I'd like to welcome you to this event. I was thinking as well that I actually haven't done jurisprudence for some time. I used to teach it many, many years ago. I'd forgotten how enjoyable it is. And I only remembered this because Femi very kindly sent me an assessment to look at in legal theory. And it all came flooding back, just how enjoyable many of this areas is. And I won't deny for a minute that the university and the law school itself has a particular bent towards, sort of applied law rather than pure theoretical law. But that doesn't mean to say that we shouldn't do events like this, but not only that, actually expand upon events like this, because I think actually in terms of education, having a more rounded perspective, we were talking about this earlier, weren't we? A more rounded perspective from, the student's point of view is a very valuable thing to have. So it's great pleasure that I have in introducing this particular event and welcome everyone to the law school and Robert Gordon University generally. Okay, I hope it all goes very well. Right. Am I within 5 minutes? I'm usually over time, so pretty good, on that. Excellent. Thanks very much. Thanks.
Thank you. So I'm now going to introduce Associate Professor Idowu William to begin his talk on theories of law and morality, perspectives from contemporary African jurisprudence. And we're going to speak for around 10 to 15 minutes, and I'll give a little nudge at 10 minutes in for the speaking now. So thank you very much.
Okay, thanks to everyone. Without wasting time, the title of my presentation is Theories of Law and Morality, Perspectives from Contemporary African Jurisprudence. I've been a student of the philosophy of law, student of jurisprudence for some decades. And I discovered through research that the African jurisprudence caste has been either misrepresented or underrepresented. And that got me thinking. And so while I tried writing my doctoral dissertation, I then made a decision to focus on African jurisprudence. Precisely, the thesis of my doctoral presentation, the title is A Critique of the Separability Thesis within the context of an African jurisprudence. The first thing I discovered is that in the ultimate sense, the challenge to African philosophy, as it were, in general, and in the particular sense, to African legal philosophy, has been that challenge, that limitation posed and imposed by Eurocentrism. According to Chandra Mohanty, Eurocentric jurisprudence places itself as the parameter through which any legal idea ought to be judged as either good or bad. I felt something needs to be rethought, so to say, in that line. And that was the reason why I decided to do a bit of research concerning the content and the contour of African jurisprudence, the capacity that it carries. And so this was one of the things that led me to this publication. Now, the paper comes up with 4 objectives, just 4 objectives. Number 1 objective is to provide a constructed contribution to the substance and the subject matter of imaginative jurisprudence. I'm sure students of law, particularly students of jurisprudence, need to celebrate the legacies of Professor Lon Fuller and that of H.L.A. Hart of blessed memory for the kind of stuff, imaginative stuff, that they gave to the field of jurisprudence. Now that's one. And in that light, the 6 theories that I have developed here, I can consider as constructive creations, so to say, to the field of imaginative jurisprudence. The second objective of the paper and the presentation is to broaden the scope, given what I said earlier, that the African jurisprudence caste has been either misrepresented or underrepresented. I felt that through this paper and presentation, it is important to broaden the scope, the frontier, including the substance and the subject matter of contemporary African jurisprudence. So this paper is a contribution to that field. The third objective of this presentation and the paper is to present a kind of constructed contribution to mainstream jurisprudence. If indeed African jurisprudence has been underrepresented, then it behooves legal scholars in Africa within the tradition of African philosophy to do something worthy of attention, something cognitively celebrative, so that Western jurisprudence can feel the pulse of African jurisprudence. And then the fourth objective is to present and provide, by way of challenge, a critique to existing thoughts, legal positivist thoughts, on what is popularly called the separability thesis. These are the objectives conceived and that made me to put up this write-up. Basically, it is an attempt to place a representation in mainstream jurisprudence about what African jurisprudence is all about, so that even if it has to be misrepresented, at least something will exist to be misrepresented. And if it has to be represented, there will be a particular content that ought to be represented very well. Of course, that can be critiqued, that can be challenged. But when it is challenged, it will not be challenged on the basis of prejudices, but it will be challenged concerning the worth that it presents, that it projects, and that it brandishes to the entire world, the community of scholars. Then, in this paper, 6 theories were imaginatively created. These are the theories of epiphenomenalism, still on the relationship between law and morality. The theory of the thesis of epiphenomenalism, the thesis of assimilationism, the thesis of accommodationism, that of culturalism, and then also number 5, the thesis of derivativism, and lastly, the thesis of conceptual complementarism. Now, according to what we have before us, each of these theses of theory has a qualified meaning. Epiphenomenalism states that the relationship between law and morality is an imbalanced one. The balance of advantage is in favor of morality, because the thesis states that law essentially is a byproduct of morality. That is, the origin of law can be traced to that of morality. So in this case, law is the epi, and then morality is the phenomenon. That is the meaning of that thesis. I go to the second thesis, assimilationism. Simply stated, it means that law is an assimilation of some of the qualities of morality. So in this sense, it is law that does the activity, not necessarily morality, although one can still argue that there's a sense of relationship. The third thesis is accommodationism, which states that law is the incorporation, an attempt to accommodate some of the essential features of morality. So that in this case, we can also argue that the balance of advantage is on the part of or in favor of law still. And then quickly, I go into the fourth thesis. The first thesis is all about the thesis of culturalism. One thing I've observed about the thesis of culturalism is that if examined properly, it will mean that the attention ought to be focused on culture, because the thesis states that both law and morality are cultural products. They are cultural resources. And so in that sense, my feeling is that if we pay too much attention to that, it means that the essence of the study will shift away from jurisprudence and then go into studies about culture, an attempt to know how law and morality reflect or manifest as cultural products. Then the fifth thesis is the thesis of derivativism. The idea of the thesis is that law is a derivative of morality. As a matter of fact, when we talk about the validity of law, law derives its validity from the respect it pays to morality or moral contents. And then again also, it says that in sense of obligation, if we have any sense of obligation, it will mean that that sense of obligation derives more from the realm of morality rather than legal, because law is not worthy to be obeyed just because it is the law, but the law ought to be obeyed because it has something that is morally praiseworthy. And then I go to the last thesis, which is the thesis of conceptual complementarism. I then realize that what this thesis says is that both law and morality are complementary concepts. And because they are complementary concepts, it shows that there's a sense of logical or empirical necessity between
That's
both
10 minutes there for you.
Between law and morality. And then part of the observation of this presentation, my paper, is that in the first instance, when we look at each of these theories, especially epiphenomenalism, assimilationism, accommodationism, derivativism, and then culturalism, we discover that the kind of relationship that is thrown up between both law and morality is something that is lopsided. And that to that extent, it doesn't seem to have that cutting edge in placing a confrontation, if you like, or a critique of legal positivist separability thesis. But then my concern and my observation, and perhaps my own favored position, is that it is only the thesis of conceptual complementarism that seems to place a favorable and positive critique to legal positivist and separability thesis, in the sense that if law and morality are conceived as conceptually complementary, it does not mean that one is compelling oneself to the conclusion that both law and morality are the same concept. No, it is not. What the thesis is actually saying, and I feel it is more representative of contemporary African jurisprudence, especially when we go by the metaphysical worldview among the Yoruba people, among the Igbo people of, Eastern Nigeria, and then if you go into the hub of Barrett's and jurisprudence in Northern Rhodesia, former Northern Rhodesia. Now, my point is this, that if we are to provide an excellent critique, exceptional critique of legal positivist separability thesis, I would say that the thesis of conceptual complementarism seems to have provided that cutting edge, in the sense that if two or more things are regarded as conceptually complementary, it does not mean that they are the same. In fact, they don't have to be the same. But as long as it can be proven that both are complementary, then it means that they cannot be conceptually separated, because it means that both law and morality will need each other to do what they have to do, either in the abstract sense or even in the empirical sense, maybe in societies. And so for me, if we are to understand legal positivist separability thesis very well, I think the limit for me stands where it is said that as long as two things are not the same concept, then they are separable. I feel that in jurisprudence, the beauty of jurisprudence and jurisprudential thinking ought to transcend that limitation, to contend that if two or more things are complementary, then the complementarity that they enjoy really shows that both cannot be separated. That is the main thrust of my argument. Now, all these theses were never in existence before now. It was during my doctoral examination that I created imaginatively these theories as representing, the body, the substance of contemporary African jurisprudence, so that even in mainstream jurisprudence, it can serve as a basis for which African jurisprudence can be assessed and for which it can be critiqued, and that for which even future legal philosophers in Africa can continue, to robustly think about. Thank you very much.
Thank you very much for that talk there. That was very interesting. And I think we now have our response to this from Professor Stavert, if you'd like to take the floor. And I will do the same time for yourself as well. So thank you both.
Thanks very much. Thanks for inviting me today. And thank you so much, Idowu, for your really interesting papers and your presentation just now. And I mean, I agree. If we're going to meaningfully engage internationally regarding jurisprudence, we really need to respect the legal traditions and ideologies of other cultures and take them seriously. And I've just sort of got a few thoughts. I'm no philosopher. I did teach jurisprudence in the dim and distant past, but I do have an ongoing interest in comparative laws and how effectively we can make accurate and meaningful comparisons between laws of different countries with different historical, socioeconomic and cultural and religious backgrounds. And at the same time, I'm also interested in evaluating such laws using international human rights standards. I'm probably going to ask more questions than answers today, I think, as I've already said. And I certainly take issue with the positivist view that law and morality is separated. I agree that laws can never be morally or culturally neutral, and its content and implementation is inevitably influenced by prevailing values and socioeconomic status of the state at the time the laws were made or they're being implemented. And even if you can say that legislation, for example, is neutral, its interpretation is inevitably going to reflect cultural or moral values at the time, and that's even more so the case with case law. And obviously, you know, countries that also, as a source of law, use custom. That's going to happen there. I have to say that I'm coming from this, just well, you know where I'm coming from this, although my initial interest was comparative laws and cultural relativity in relation to internal security laws. The bulk of my academic career has been looking at mental health, mental capacity laws and human rights, and sort of questions there arise as to you know, what's acceptable in terms of intrusion of someone's individual autonomy in different cultures and impacting on the exercise of legal capacity. And when you come to supporting someone's legal capacity, the nature of that support will maybe differ according to different cultures, and how we define harm to each other, it differs as well. But at the same time, I'm really conscious when you're looking for a means by which you can compare and evaluate comparative laws. When you look at international human rights, I mean, there's the argument by some governments and commentators that the so-called international human rights standards that we have are a construct of the developed Western Christian world that focuses on individualism, and therefore it has very little or no application or relevance to developing nations, to non-Christian nations, and particularly those who have a greater sense of community and the individual's relationship with community. And I noted that in the second of your two articles, you referred to the community, the greater sort of community aspect of ideology and law in African countries. And I think this raises a number of questions. For example, just how much law is a reflection of a particular culture and a particular set of values. And you pointed out when you were describing the 6 theses that often they provide an inadequate explanation about the impact of cultural moral values on the law. Although you do say that contextual complementarianism is possibly a way around that. But even if you can determine that a particular culture, a particular set of related values is incorporated or is reflected in a particular law and its implementation, to what extent can anyone from outside that cultural context legitimately critique them? And I'm interested about how we can do that, because it would be a great shame if we couldn't do that and engage in it. So what's the basis, what's the framework for that? And colonial, and as you also say, colonial law, for example, didn't impose by abolishing or ignoring itself on an effective blank page in Africa. there was an existing law and legal philosophy, and this seems to have been absorbed to some extent, but not entirely, by colonial law. But at the same time, you also say that the sort of study and the legitimacy given to African legal philosophy has been dismissed by Western commentators, and seeing the Eurocentric model as being the superior framework. So how do we get round that? I suppose the other thing is that, and this applies to every part of the world, that culture and morality is dynamic. It evolves through time, through internal and external influences. And obviously now we have globalization, and that impacts on every culture, but does it impact in the same way? And so it's very difficult to ascertain whether what you're looking at is a particular set of cultural values and which ones are prevailing at any given time. And so I was wondering what you could, when you look at the sort of contextual situation or conceptual situation, is there anything that you think would allow for cross-cultural comparisons to be legitimately made? I mean, to my mind, if you look at international human rights standards that are arguably identified in international treaties, we could perhaps take those and say that those represent a sort of core basis of shared values across the world, but accept that they might have to be implemented at national level in a culturally sensitive way. And that would allow for the sort of shared values and the comparisons to be made, but would prevent, for example, cultural arguments being used to justify oppression or starvation or physical harm, etc. And again, that applies across the board. And I also wondered about the you as one of these sort of core shared values, or whether the notion of dignity would fit the bill. Jack Donnelly years ago suggested that rather than sort of talking about rights, we should talk about dignity and what it is to have dignity and to preserve that. Although I also noticed that McDougall, Laswade and Shen wrote that describing dignity as the basis for a natural law approach can also be problematic at national level, because it can be used to justify, on the one hand, genuine respect for dignity. On the other, it can be used to justify perpetrating indignities. And so again, we sort of have the problem that, of what can we definitely use as a linchpin to make these comparisons. That's all I really wanted to say. I find your article very, very interesting, and I'm sort of more interested to hear what you have to say about it, and also what other members of the audience today have to say.
Thank you very much, Professor Stavert. I wonder if Professor William, you would like to come in and respond again before we open it up to the audience for the further conversation, if there's any points you would like to respond specifically.
Well, whatever order you have decided to go by, it's all right by me. Of course, I picked some few things from Professor Jill Stavert's review. For example, what is the basis of comparison? And then what do we say about the issue of human rights and dignity? These are some of the things I could pick from our review and our presentation. So if you want me to respond to that, I can easily do that. But then if you think the audience will come in, and then probably we then, treat the questions all together, that would be all right. It depends on what you have chosen.
I think in terms of, if we have, a little bit, we're ahead of time. So if you wanted to spend a little bit more time expanding, and then we could go back to the audience after, if you wanted to spend more time on some points, I think if that is okay. I think with Femi, I can't see the room, so I can't see if there's hands up or anything at the moment, but please do take this opportunity. We'd be very appreciative of.
Okay. Now, in the first instance, my work essentially is not about comparing, although elements of, comparative insights can be discerned and be spotted in what I have presented. There's no basis for comparison in the sense that, just like Professor Stavert said, that if you are not an insider, how would you be able to do justice to the kind of comparison one wishes to do? But you see, basically, my attempt, like I said earlier, my attempt is to see how the limitations imposed on the African possibility can be transcended by Africans themselves. In other words, the regime of silence, the reign of silence is no longer tolerable, nor is it fanciful. There's no aesthetics in keeping mute. If it is the case that what Africa holds as our possibility is being misrepresented. Now, that was one thing I spotted, like I said, and I felt that I could put up a reaction to. A reaction not necessarily from the perspective of ideology, but a reaction from the point of view of critical thinking. I am not a sociologist. I am not an anthropologist. I'm a philosopher. I could sit in my office and then pontificate, postulate theories. Exactly that was what I have done in this paper. I mean, like I said in one of the slides, all these theories never existed hitherto. But because I was bothered about the misrepresentation, or if you like, the underrepresentation of African jurisprudence, that was what led me into creating, innovating, so to say, as it were, going by years of experience in legal philosophy, just to say, look, Africa can be understood in this respect. And so some of these things can constitute that respect that Africa deserves in terms of its legal values. And so in doing the work, although I had to rely on some empirical data from existing African legal philosophers, but who did not put a theoretical capstone to what I did, I felt one way by which the frontiers of African jurisprudence can be extended is to come up with those theories. And so that, I mean, exactly what is happening now, those theories can be examined and they can be critiqued. So my point in all this is that I am not at this level, not interested in comparative jurisprudence. All I desire to do, and that I did, was just to present a theoretical imprints through which African jurisprudence in contemporary times can be understood, particularly in relation to the connection between law and morality. Another thing I wish to say quickly is that concerning the issue of human rights, dignity, look, it is true. It is true that even in Africa, there are questions about human rights. There are questions about dignity. In election matters, for example, you experience riggings and what have you. But it's one thing to have a moral standard, a legal standard. It's another thing for people to abide by it. And I do not think that is peculiar to Africa alone. Human rights questions are bound everywhere, all over the world. The important thing as scholars and researchers is to come up with blueprints of ideas at the level of critical thinking, present them for the world, and even for policymakers, politicians, policymakers to examine, and that those things will exist in their conscience, that these are standards, even if they claim not to know, but those things will have been there. So if concerted efforts are made to present theories like this, present ideas like this, for the practical world to know, I think enough justice must have been done. So one, it is not to compare, but to come up with ideas through which the African jurisprudence caste can be well represented. And like I said, it is not to spare it a sense of critique. No, any theory that is avoiding or making an attempt to escape from being critiqued, I do not think that theory or that idea is worth it at all. Every idea that is worth it ought to be represented in the world and then be critiqued, so that even those who belong, or maybe those who postulate such theories, can then think of ways through which such ideas can be, rebranded. And once it is rebranded, then the discussion will continue. Those are the things that I have tried to do. Essentially, make sure that the challenge, the limitations of Eurocentric jurisprudence is removed. Because, one of the papers I have written, I share the view that what is called African jurisprudence, if you go into main text jurisprudence, if you go into main text in jurisprudence, you hardly can find any such thing. Those were some of the things that disturbed me and that made me to come up with this attempt. And it can be critiqued. It can be critiqued. That is why we are doing this. Thank you very much.
Thank you very much. I will now open up the conversation to people in the room, but also people online to respond. I think the best way would be for Femi to field some questions from in the room, but if there's anyone who'd like to contribute online, if you either put up your hand or you could put a question in the chat and I will share it. So Femi, I'll start to see if there's anyone in the room who would like to comment or make a response to both of our speakers.
Okay, we have somebody here with a question.
I think my face keeps coming up on the screen as well at the back, so apologies everyone.
No worry. Yes.
Thank you very much, Mr. Idowu, for your wonderful presentation and the reviewer's response. So I had the rare opportunity of reading the paper in advance, and from all the theories discussed, the theory that appealed to me most was the thesis of conceptual complementarism. And it seems most plausible to me because law and morality seem to complement each other in African jurisprudence, even though they seem separable or distinct in some respect. To me, they complement each other. But as plausible as the theory seems, there are some questions that baffled me while I was reading the paper. The first question is, how does conceptual complementarism account for the differences in moral beliefs within the same society and culture? What I'm trying to say is that, how does the thesis account for maybe in a single society, there are different moral beliefs? So what would be the connection between the law and morality in such society? Secondly, looking at the law from the prism of legal realism, what do I mean by legal realism? By legal realism, I simply mean the role of judges in shaping the law based on public policy and the judge's personality. So looking at the law from that prism, sorry, can you hear me?
Yes, definitely. Very clear.
Yes, we can hear you.
All right, thank you. So looking at the law from the prism of legal realism, How does the thesis of conceptual complementarism contend with the ability of judges to shaping the law without recourse to morality? I'll rephrase the question. What I mean is, looking at legal realism. Okay, you got the question. Oh, that's fine.
Of course, I got you.
Okay. So those are my two questions and my main concerns about conceptual complementarism. Thank you.
Thank you very much. Can I offer any response?
Please do, yes, please do.
Can I?
Yes, absolutely, please do.
Oh, thank you so much. Thank you. Thank you for the two questions. In the first instance, you see, when philosophers talk, we talk at the level of abstraction. We talk at the level of possibilities. Now, the possibility ingrained in the thesis of conceptual complementarism is the idea that both law and morality do not necessarily have to be the same, but as long as the complementariness can be proven, that's all that that thesis is concerned with. So, in relation to your first question, it doesn't have to follow that there are several moral beliefs. The point is that at one point or the other, if the idea of complementarism is evidenced, then it means that law cannot run away from morality. As a matter of fact, law is like I'm sorry to say, I hope it will not be pejorative. Law is like a thief, like a robber. Why? Because it goes to the nucleus, the den, the enclave of morality to sanction some other things, some things in society, some kind of behaviors, some kind of conduct as illegal. And by the time you examine what is branded as illegal and that is forbidden by the law, there are moral issues. What do we say about adultery? What do we say about stealing? Initially, so to say, these are moral ideas. And so you find law pronouncing a kind of a detestable stance against some actions, human conduct that are considered as illegal. But when you re-examine, you discover that those human actions and conduct ab initio emanated, emerged from the realm of morality. So the point is that what conceptual complementarism is actually arguing out, if it is accepted, is that no matter what, even if there are dozens of moral beliefs, as long as it is true that there is a sense in which law cannot do without morality, that's what the thesis is all about. And like I told you, philosophers just, we ratiocinate at the level of abstraction, not necessarily in the empirical sense. The second question, it is obvious. Oliver Wendell Holmes Jr. defined law as the prophecies of what the courts will do. In actual fact, and nothing more pretentious are what I mean by the law. So what it means, and if you look at that great jurist, Oliver Wendell Holmes, he made mention in the part of the law, he made mention of the bad man. The bad man does not care about morality, yet he cares about the law. However, when they dispense justice, don't they refer to morality? In any case, the law that they pronounce on in the process of validization, is it not the case that some moral nuances have found their way into such laws that judges pronounce in the court of law? So at one point or the other, you discover that what judges often refer to clearly are not legal statements, they are not legal principles, but moral principles in deciding cases. And we have found that in history. Thank you very much, sir.
Thank you. Professor Stavert, I wonder if you wanted to respond to that, if you had a response to that as well, if you wanted to come in or add anything to that?
I think it's just a sort of observation, and I'm sort of struggling with it as I'm actually sort of working it out as I speak. So I hope this isn't too rambling and unclear. I can absolutely understand that law and morality are inextricably linked, and I think your expression you used, that law is a thief, it sort of takes from morality. But again, when we look, and you, as you said before, you know, we can critique each other's laws, but my concern is that if you are critiquing another culture's laws or another country's laws, how can you do that without bringing your own? If you don't have some sort of shared sense of core values, how can you do that without it being biased? Not necessarily in a bad way, or a prejudicial way, but that you will necessarily bring your own values, your own legal philosophy, and the values attached to that into the argument. So it's how do you effectively do that? And it would be a great shame, it seems to me, if we couldn't discuss and critique, not necessarily in a way of criticizing the morality behind the laws, but actually just comparing.
Thank you. I've got a question in the chat box here. How can the issue of cross-cultural differences affect the implementation of international and regional obligations of countries? So I think that kind of touches upon what you were just saying, Professor Stavert, there. So I don't know if anyone would like to come in and answer this question to Kelechi. How can the issue of cross-cultural differences affect the implementation of international and regional obligations of countries?
Oh, thank you. If that question is for me. Now, the point is that I think I would like to refer to the thoughts of Lon Fuller. Whether at the international level or at the national level, even at the local level, it is observed pertinently that law cannot stand on its own, alone. So one way or the other, even in international law, the cultural beliefs, ideas, moral beliefs, ideas at a minimal level will have to be respected. For example, if it is part of international law that no other country has the right to intervene unjustifiably in the affairs of others, they could pass comments, they could do this, they could share ideas and what have you. That in itself is something significant. Significant in the sense that it's an attempt to isolate for understanding the significance, the importance of respect, mutual respect for the sovereignty. I have a feeling that underlying that respect for the sovereignty of countries is like saying, we respect your culture, we respect your views, we respect, what you hold dear to yourselves and to your country. And so at a point, it is important to stand by that. So the point I'm making is that even in international law, it is believed that even when laws are made internationally, the basis of such laws is the respect. And those respect, they come from the understanding that every country seems to have certain cherished ideas, maybe cultural, maybe moral, maybe religious, and what have you, that underlie, those laws that are accepted as part of the canons of international law. So at what point or the other, it may be at the minimal level, but at what point or the other, those cross-cultural ideas, values are part of the respect that we have interred in international law today. Thank you.
Thank you. I wonder if there's any other questions from the room, Femi?
Yes. Just sit down. Yes.
Greetings all. Am I on?
Hi there, we can hear you.
Hi, all right. So I feel a bit nervous. I don't know if it's because of what I'm going to say or because of everything. But so my name is Tinashe. I'm from Zimbabwe. So, and I found all of this very interesting because I obviously come from a very small country. It's on the continent. So I am, I think, for all intents and purposes, an African. And I've only been here for a year. So I'm speaking from, a perspective that I think is influenced by different experiences from different regions. And I find when I think about all of this, I find that there isn't really that much difference from my perspective. Because even if we go into Professor Hart and what he was arguing, I mean, at the time, homosexuality was not what it is now. And Professor Hart was battling with that and the morality of that and the role of the law in that. And similarly, I mean, if we go to, we had a contribution about legal realism and the fact that you can't escape morality impacting the law. These are all ideas that we find across, whether it's an Afrocentric perspective or it's a Eurocentric perspective. So my challenge is what we end up doing, and what I think we end up doing, is we end up focusing on the difference and not necessarily the same things. And so I'll round this out by saying, like, for example, when you talk about human rights and the need for distinction and the need for differentiating among people and among the people's perspectives, I think what it boils down to and what it boils down to is the same theorists agree on something like the rule of law, and the rule of law captures all of this, right? And the rule of law is consistent across the globe, in my opinion. How you apply it might differ a little bit, but it's the same. People in a community want accountability, and that's really what it is. And I think jurisprudence and the morality of things and the role of the law can always be captured in the idea of accountability, and how people do it is going to be determined by what they regard as being most important. So ultimately, I find value in this. I think it brings us closer because we start having conversations. And my hope is as we have these conversations, we get to a point where we realize that we're generally the same. It's just we approach it differently. Okay, thank you.
Would you like to respond?
No, I mean, there's nothing to respond to. I find the viewpoint and the position of the speaker quite interesting. And I think it is complementary as well, because my argument all along actually is not, like I said, I'm still insisting on that, is not to compare, but just present issues from the perspective of the realities available amongst Africans. It doesn't mean that it has to be different. No. I mean, there are societies in the Western world who cherish and embrace morality, perhaps in toto, in a way. And so, and of course, there are societies in Africa also who have a bit of a rejecting stance against some, some moral values. So it means that it is neither here nor there. So I'm not saying that we should compare, just like I said at the beginning. But what the last speaker said is actually complementary to what I've been saying all along. Basically, my intention is to present what needs to be understood, and so that it can be, critiqued from what it has presented. That's my major objective. Thank you very much.
Professor Stavert, would you like to join in with anything?
No, I agree, and I think where I'm coming from is a sort of more of an applied approach to it. Is that I think it is. I think it can be presented and it's interesting, but I think it's when you're trying to make comparisons for the purpose of what works and what doesn't work. And I'm very interested in law reform. So you look at other countries and you see a particular law that appears to be working very well, doesn't, and you have to ask yourself, well, is it the particular culture context within which that law has been created, and that it makes it work in that culture, whereas it would have no applicability in our own culture. I think that's where I'm coming from.
Thank you. I wonder, I'm just looking at the time, so I think we've got maybe one last question in the chat, and then I'll hand it over to Femi to tie up. So it says, dear professors, with mental health issues currently on the rise and some of the sufferers being subjected to legal processes, how can the legal and moral obligations due to them be sustained in a cross-cultural way in line with African jurisprudence and philosophy? And that's from Archie Effiong in Bedfordshire. So I wonder, Professor Stavert, if you'd like to respond, and then we can have Professor William follow you in that response to that question.
Yes, sure. Thank you. And it was actually Archie's question is actually very, very much what I was trying to get at in my last comment. I think it's the need for sort of shared values about what and what is not acceptable in terms of how we treat each other, but the way in which that's implemented may be different according to different cultures. So, for example, some cultures do feel that informal approaches to supporting people with mental health and mental illness are preferable to more formal structures. We tend to sort of favour the more formal structures in Western jurisdictions, but we know there are some very good examples of less formal non-statutory interventions that are used, and it's understanding that. But again, it's do we have a shared sense of what it is and what it isn't to be a person, and what a person's needs are. And it goes back to the autonomy issue as well, and the price paid on individual autonomy, and how much that has to be restricted in supporting each other. And that's why we need to understand it in the context of different cultures. I hope that answers your question, Archie.
Thank you. I'll just ask Professor William to respond, and then I think we're coming up to our time, so I'll let Professor William to respond, and then I'll pass it back to Femi following this. And I think there's opportunities for further discussion beyond the time that we have allotted. So Professor William, would you like to come in again?
Okay, yes, I'd like to respond to the last question. From the African jurisprudence perspective, there is a research I am undertaking presently, and it has to do with the therapeutic foundation, the therapeutic dimensions to African jurisprudence. In some of my researches, published actually, I came up with the conviction that if there's a theoretical label that ought to be given to the nature of African law, it is in the fact that it is essentially, elementally reconciliatory in nature, which means that that kind of orientation to the understanding of law conceives law not necessarily from the adversarial dimension, but to admit of elements of reconciliation. Now, if that is true and so, what it means is that there is a therapeutic element in that kind of conception of law. If the idea is never to say the winner takes everything, but that even if there are disputes, even if people are disagreed in society and they have to come before the court of law, it is important to understand that the first thing is to see how to maintain the cohesion of society by understanding the points of those who are involved in the conflict and see to how they can be reconciled through the instrument of law. Now, I'm still on that research, but the point I'm making is that if it is true that there is a therapeutic element in the nature of African law, that is one way by which the issue of mental health, mental problems can be approached, at least from the perspective of jurisprudence, from the perspective of law. If law has a therapeutic element, a therapeutic dimension, then it means that from that perspective, we can commence the process of mental healing in our society. Thank you very much.
Thank you very much for those comments. And I hope everyone who wanted a question can put them in the chat again and carry this on. I think Femi is going to give some information about continuing the conversations and also the series. But first of all, I'd just like to extend my thanks to both speakers and the audience today for taking their time to join us in this nascent and maiden cultural conversation, which is very interesting for someone like myself who doesn't have a legal background, a really thought-provoking pause on law and morality from someone who works in media ethics. It's interesting to think about the boundaries and complementarian aspects of these. So thank you for sharing your expertise. Can I just give a thanks? I think we can do a virtual clap and also a room clap as well. We can do a clap and also a reaction, but thank you very much. I'll pass on to Femi now for some few words. Thank you.
Yeah, I would like to thank everyone that has sacrificed his or her time to make this happen. I would just, before I give the vote of thanks, I want to just go back to the question that my colleague asked about the issue of African culture and where we have to dwell on it. By virtue of training, I am dedicated to exploring the relativism and universalism in international law. So which means I am a theorist in international law. For one, yes, humans are the same. Your exposure, your experience all determine the kind of worldview and culture and legal positions you take. And if there's anything that is different, maybe it or to shape the identity of individuals, it has to be time and space where you find yourself at a particular time. And then the experience you have, before I start to go into, encroach into the territory of the invited guest, I think I will stop. And I am interested in the uniqueness, if there's anything unique about the African, and I am interested in knowing about it and gaining insight into it so we can engage meaningfully with each other, and that is the essence of the conversation. I actually got the inspiration, I must thank them in absentia, a few months ago when I was teaching some postgraduate students here. And at a point in time, they said, okay, we should be able to do something together. And I say, well, we will do something together if you can make for the time. Some of them are here, and I want to thank every student that has participated in making this happen. They have silently and greatly worked to make it happen. I have the assistant librarian here, who is also actively interested. I must thank you, Paul. It was just a general notice, and usually the kind of person he is, he wants to make sure that we are encouraged. That is very, very encouraging. Thank you for making it here. We should thank John Clifton, the head of school too. He was here to give the opening remark and then had to leave. Many years ago, if I was pushed to do this, I wouldn't even volunteer to do it. I think Paul can understand. But we have a platform, so we must be appreciative of that. To every participant, Fiona McKay, that was a very super moderation. You have set the standard. Jill, you've been very, very friendly, but you help us to know more of what we need to know. And to our invited guest author, you did not disappoint us. Thank you very much for coming so prepared. Now, good news, for the next series of the conversation, it is going to take place on Wednesday, the 31st of May, same time. And we are inviting a professor from South Africa, Professor Iya, from one of their universities. And the guest reviewer will be one of our forum member, Professor Matthias Boddick, who happened to be the deputy head of school of the University of Aberdeen. Details will follow. For now, let the conversation continue online. Thank you. Back, Fiona.
Thank you. And I think, would you like me to share the Facebook link in the chat now?
Yes, that would be helpful.